Hello, everyone. Welcome to Multnomah Group's webinar for today. Thanks to everyone out there who made it to today's webinar. We really appreciate it. And so welcome to our webinar. It's the 2016 Regulatory Update, Action Items for Plan Sponsors. My name is Jennifer Tamayo, and I'm the Marketing Coordinator here at Multnomah Group. Before we get started, and before I introduce today's speaker, I would like to start with a few quick housekeeping matters. First and foremost, again, thank you for taking time out of your day to join today's presentation. We hope you find the material useful in your practice. You will find that your line is muted. If you need assistance during the webinar, please use the question pane on the right-hand side of your screen to enter comments, including any technical assistance you may need with the audio or visual. Second, there will be a question and answer session at the end of the webinar. If you would like to ask a question, feel free to enter questions throughout the session, again using the question pane on the right-hand side of your screen. Please note that today's session will be recorded. You will also receive a copy of today's slides via email, along with a link to the recording of the session. You will also find a few handouts of interest, including a copy of the slides and the printed regulatory update that accompanies today's presentation, available in the handout section on the right-hand side of your screen. And again, if you experience any issues and you don't see those items, definitely let us know. Finally, there will be a short survey at the end of the webinar. Your feedback is important to us. We encourage you to take a moment at the end of the webinar to submit your responses. Without any further delay, I would now like to hand over the presentation to one of our senior consultants, Bonnie Treichel, to get us started.
Thank you, Jennifer. As Jennifer mentioned, my name is Bonnie Treichel, and I'm a senior consultant here at the Multnomah Group. I'll be walking you through the webinar today, talking about the regulatory update for 2016. As I was looking through my notes a moment ago, I realized that the DOL and the IRS have definitely been busy, so we've got a lot of ground to cover today. But first and foremost, thank you for your time in joining the webinar. We know you have a lot on your plate as a plan sponsor, so we really thank you for your time. Second, we want to point out that most of what we cover today will be focused on plan sponsors. We'll touch on the impacts to others in the retirement plan space, but during the webinar, we will continually come back to what will be important for plan sponsors, and thus most of our action items will really be focused on plan sponsors. So with that being said, we'll get past the housekeeping matters, jump into the agenda, and then we'll go from there and head into the actual presentation itself. So what are we going to cover? First, we're going to start with talking briefly about the authority, or rather, whose rules are we going to talk about? Then we're going to move into a litigation update. So I know that's really top of mind for a lot of you out there. In general, we'll keep that fairly brief because we'll also have a follow-up webinar to that. Eric Daly, Managing Principal here at Multnomah Group, will be hosting a webinar on September 20th at 10 a.m. Pacific. He'll be joined by Drinker-Biddle attorney Richard Pearl, who works in ERISA Litigation, and they'll be doing a webinar in which Eric and Mr. Pearl will discuss in further detail the history of class action suits against plan sponsors, some of the recent settlement structures, the new wave of these cases, and steps to improve fiduciary documentation and participant communications. So today we'll just keep that pretty high level. Then next we'll turn to the DOL's conflict of interest rule. Again, we did a webinar on that last month, so we'll keep that pretty high level as well. And if you want to see a replay of that webinar, be sure to check that out on the Multnomah Group website. Then we'll go ahead, and after we've covered the DOL rule, we'll turn to some of the items that the Department of Labor and the IRS have acted on during the past 12 to 18 months. And a lot of those items have resulted in outcomes that may be affecting your plans today. So for example, we'll touch on socially responsible investing and the Department of Labor's guidance there. We'll talk about the DOL's Auditor quality study and some of the results and what the DOL might be looking for there. We'll talk about the upcoming changes to the Form 5500. We'll briefly touch on changes with respect to determination letters, and we'll also briefly touch on the changes in 409A and 457. The last topic we'll touch on today, this won't really require any action items for those of you on the call, but I think it's noteworthy, a noteworthy topic in retirement, and that's some of the issues around state-run retirement plans and some of the recent guidance from the Department of Labor, and even some of the final rule that came out last week from the Department of Labor. So to round out our discussion today, we'll save some time for question and answer, and then we'll also make sure we have some time for some action items and takeaways. So as Jennifer briefly mentioned, throughout the presentation, I will refer to some of the handouts that you can find in the handout pane. There's 5 of them, which does include the copy of the slides from today, as well as a copy of the written, back in July, mid-July, we did a 2016 regulatory update, and that's also available. One of the things you'll notice, and this is just indicative of the retirement space itself, is that the 2016 written regulatory update, some of the things even from mid-July are just already outdated as we sit here at the end of August. So the space is always changing, which makes it fun for those of us in it. So with that being said, we'll go ahead and jump into authority. So, where are the rules coming from, and what are we talking about? So one of the things that makes retirement plans so complicated is that there are a lot of different sources of rules and regulations to follow. And that's what makes, you guys and gals on the line such smart people, is that you're able to keep up with all of it, as well as actually a lot of different other hats that you probably wear in your day-to-day. And essentially, with respect to retirement plans, the rules and regulations come from pretty much 3 primary sources. So we've got the Department of Labor, the Internal Revenue Service, and litigation, or we have cases that are brought by plaintiffs or employees, and then from those cases we get case law sometimes if there's not a settlement. And we do recognize that there are other sources. So for example, legislation such as the Pension Protection Act, for example. But today we're going to really focus on those 3 sources of authority to guide our conversation. So with that being said, I think we'll turn to our first area, which is the litigation update, because I think that that's really top of mind in most of the client conversations that the consultants here at Multnomah Group are having right now. It's really, the questions around litigation and what should plan sponsors be doing to avoid litigation so that you're not entangled in that. So I want to start with some potential areas of litigation. Obviously, the most obvious one is excessive fee cases. So we'll talk about that a little bit more in a minute, but I think that jumps out as that's one potential area for litigation is excessive fee cases. 2 other areas of potential litigation, I think in the coming years include, first, litigation as a result of the Department of Labor's conflict of interest rule, and then also target date funds, and that's just to name a couple areas. So with respect to the DOL rule, or the DOL's conflict of interest rule, the department created a private right of action, which makes lawsuits potentially more prevalent. But also, I think just with that rule, the DOL created greater awareness around fiduciary issues, similar to the way that happened after 408B2 and 404A5 back in 2012. So with that rule, we had the Obama administration really getting behind that rule, and so I think that just creates greater awareness, which also can create greater potential for litigation. So as such, I think it'll take a little time, but eventually I do think there could be new litigation as a result of that DOL conflict of interest rule. Also, in my opinion, target date funds. This is where a lot of the assets are today, given the prevalence of the automatic enrollment programs. So as such, I wouldn't be surprised if we start seeing more litigation related to target date funds. And in fact, there was just a case at the end of last week that really was focusing on target date funds in that Safeway case. So I think another area that I would want to just touch on briefly would be the way that we've seen litigation start to move what I would call down market. So we saw when ERISA cases, started to pop up, it was really related to these big Fortune 500 companies, right? So we saw it with Kraft and Caterpillar, companies that I would describe as companies with big pockets. But we've recently started to see this year companies, smaller companies, so a company with 114 active participants in the plan and only $9 million in total plan assets. That was a case that was filed back in May. Or we saw, another case with only $25 million in total plan assets. That was a case I think that was filed in July. So I think, we're seeing a movement down market in some of these cases where there's lawsuits filed not just against the really big Fortune 500 companies. So that's somewhat of a shift in what we've historically seen with ERISA litigation. And last but not least, there's obviously what's top of mind, the new wave of litigation against colleges and universities. And in total, I think there are 12 cases that have been filed against colleges and universities in these recent excessive fee and breach of fiduciary duty cases. And while each of these cases really offer unique aspects, they do share similarities that I think can be helpful for other retirement plan fiduciaries that seek to try to prevent litigation. So, there's several claims in these cases, but I think I'll name a few of them just to kind of throw out some of the similarities among the cases. So, for example, we have claims such as multiple record keepers, and so that the claim is that because of having multiple record keepers or vendors, that results in higher fees for participants. Another common claim is, there's too many total investment options, and so that creates confusion for participants. Or similarly, that there's duplicative investment options, and again, that's creating confusion for participants. Another claim, the investment advisor has an alleged financial connection to the university select, and so, that's a problem as well. So there's the argument as well that revenue sharing arrangements that led to excessive fees to service providers or as kickbacks to the sponsor company. Arguments as well that the plan utilized funds that contain multiple expenses or they argue multiple layers of expenses. And then another argument that we've seen in other cases that the plan used actively managed rather than passively managed funds, and that there really wasn't a performance benefit that really justified that, and then justified those higher fees. So again, that's not an exhaustive list of the claims, but it gives you a taste of the claims that are out there in that new wave of cases. And you might want to check out one of the handouts that's included is a one-pager, and it just goes over a summary with some additional information on those claims. So, really, why do you look at these cases? Why would that matter for a plan sponsor? If we go ahead and we'll turn to the next slide, and we've included just some questions for consideration. Keep in mind, anyone can file a lawsuit at any time, and that's going to be out of your control. But it's much better to be able to defend yourself with proper documentation and best practices and the proper processes in place that will result in an opportunity for you to achieve a very low settlement or an early motion for summary judgment and to get potentially the best outcome for you, which would be no litigation at all. So we've put together a few questions for consideration that you may consider running through, just to ensure that you've got the best practices in place to help you defend against litigation. So just, feel free to take a run through. You've got these in, I'm not going to go through them, but you've got them in the handout section. I do want to note that the last question, does the plan have a communication strategy to address participant inquiries about fees and other questions related to the plan? We do have a separate handout to address that and kind of some best practices for responding to participant questions. I think, one of the things that we want to be aware of in light of both the Department of Labor's rule as well as some of the recent litigation is that we want to make sure that when we've got participants who are, asking questions, that we have a good way to respond to those questions, and that we don't just let the questions sit idle when we've got a participant who hears about this litigation, given that it's, in the Wall Street Journal and that sort of thing, that we don't just let those questions lay idle without responses. So there's some documentation there to help you think through how to answer participant questions as well. So again, there'll be a follow-up webinar with more information on the litigation, but that should give you kind of a good starting point as to what those cases are about and maybe some questions to think about to help you with some best practices to defend against or to prevent litigation. So with that, I think we'll go ahead and turn to the next area for consideration on our regulatory update, which is the Department of Labor's Conflict of Interest Rule. So during our last webinar, we discussed this in a lot of detail, but I think what's really important to touch on just briefly during this webinar is that you understand, number one, what the rule is, just at a very high level, and then number two, what's the impact for plan sponsors. So essentially, the DOL has a set of new regulations that will become effective next April 2017. It's important to note that there has been litigation in attempt to stop these new regulations, but I think it's pretty fair to say, and given some of the trade press the last couple of days, there's a really high bar for the litigants to overcome, and so it seems very unlikely that any litigation will stop these new rules from moving forward. So I think both from the kind of your vendor's perspective, your other service provider's perspective, and from your perspective, you should plan on these rules will likely go forward, despite the fact that there are definitely attempts to stop the rules from moving forward. I think my opinion would be it's fairly likely they'll be pushing ahead. So as such, what these rules or regulations, they essentially have two parts. So first, they're extending retirement plan rules basically to individual retirement accounts, and they're making more retirement plan professionals fiduciaries, so basically raising the standard with which these retirement plan professionals have to serve their clients or the investors. So the rule has a lot of moving parts. But for your purposes, I think the three components that are most relevant are the ones that we'll talk about today. So there's a new test for determining what gives rise to fiduciary status under ERISA Section 321A2. So the test is really broad, so that nearly all activities by financial professionals are now fiduciary activities. So that's really the first part. Then the second part is that there's certain activities that are going to be excluded from that really broad definition of fiduciary. So those are things that aren't going to constitute fiduciary advice. So I think the thing that's most relevant for plan sponsors would be like education. So that includes activities like a financial professional just describing how the plan works, or explaining the general financial information, for example. Again, those are things that would be considered, they would not be considered advice, and so then they wouldn't give rise to fiduciary status. And then there's the third part where there are several changes to what are known as prohibited transaction exemptions. But the biggest one that I think will have just kind of a secondary impact on plan sponsors and participants that you'll start to feel would be the best interest contract exemption, which is also sometimes referred to as BICE. So the best interest contract exemption, it was created in part because under this new rule, as we were discussing, many more retirement plan professionals who've never been fiduciaries, they're now becoming fiduciaries held to this higher standard. So as a result of that, the way they were compensated has to change under the rules. They will have to now use this new exemption called BICE, or Best Interest Contract Exemption. BICE will also be used by many firms who are conducting IRA rollovers to avoid prohibited transactions related to unlevel compensation. So again, we don't want to get into the weeds because that would take up the rest of the webinar, but essentially what this means is there will be an increase in paperwork, and I think you'll see that specifically because of some of these new rules. I've been talking to some of the vendor partners or record keepers that a lot of our clients here at Multnomah Group have relationships with, and one of the things that I'm learning from some of these vendors is that there will definitely be additional steps that will result in some more paperwork for some of our clients. And so I don't think it's going to be a big hurdle, but I think be on the lookout start of next year probably for some novel disclosures, new paperwork, and I think that's something that your Multnomah Group representatives will be ready to help you work through that with those vendors. So again, just to reiterate, what does this mean for you? It means, be prepared. You may see some new paperwork, and I don't think that'll be a big hurdle, but you may just see that as a result of this rule, mostly coming from your third-party vendors, such as record keepers. And then in addition, there is actually, this is one thing to maybe perk up for, there is one new responsibility for plan sponsors. So in addition to the plan sponsor's responsibility to monitor service providers on an ongoing basis, as a result of the rule, plan sponsors now must periodically monitor the asset allocation model and interactive materials being made available to participants and beneficiaries as a part of any education program. So the final rule talks about this. The ongoing evaluation should include what they say, quote, is an assessment of whether the models and materials are unbiased and not designed to influence investment decisions towards particular investments that result in higher fees or compensation being paid to parties that provide investments or investment-related services. So, since we did the last webinar, I've talked to some of our clients about this, and I wanted to be clear that, first, I do think there will eventually be additional guidance from the department regarding this requirement that plan sponsors now have. And obviously, I think that, consultants and advisors such as Multnomah Group will be here to help clients comply with this requirement. And I think that, some clients have had some questions like, well, does this mean that we will have to go scrub the entire website or review the entire website of our record keeper, our vendor? I absolutely, don't think that that's the case. I think that it will be a much more specific requirement with respect to the actual educational materials that are being made available. I don't think it's a wholesale. Requirement that you have to go scrub the entire website. So I think that there will be additional guidance there. And I apologize, it looks like maybe the slides have not been advancing. So I think that we will get that taken care of, and it should be now that the slides are advancing. So we apologize for any inconvenience related to that. So hopefully now we should be on the conflict of interest rule slide, and we'll be advancing shortly to the conflicts of interest rule questions for consideration. So we apologize for any inconvenience related to that lack of slides advancing. So one of the things that I think would be helpful is just to briefly touch on, conflicts of interest rule. What is it that you should be doing now to prepare? We'll go ahead and advance the slides to the next slide, which is just some questions for consideration. And here, I showed a similar slide on the last presentation, but, really, the rule is coming up shortly, so I think one of the things that you can really be doing is just to be asking your vendor partners, or also if you're working with an existing advisor, make sure to ask them if they're ready for the DOL's fiduciary rule, and to make sure that your vendors are getting prepared. If they have not already communicated to you what their strategy is, then I think now is the time to really be reaching out to those vendors and making sure that you ask them what they're doing to prepare and if they'll be ready to comply come next April. And then in addition, be sure to take a look at these questions for consideration. And if you have any questions, don't hesitate to reach out to Multnomah Group, and we can talk about those in further detail. So now that we've touched on kind of the two biggest topics on today's webinar, we want to go ahead and move on to some other areas of impact that have come into play in the past 12 to 18 months. So first is the concept of socially responsible investing. So many of you may be familiar with this. It's the idea of thinking about values when making decisions about investments, or rather, investing with your conscience. So the DOL refers to this as ETIs, or economically targeted investments. But you may also commonly hear this referred to as ESG Factors, which stands for environmental impact, social equity, and corporate governance. So ESG investment managers screen companies based on their use of natural resources in the development and manufacturing process, and the environmental sustainability of their products and services through the full product life cycle. There's also faith-based mandates in which the funds invest in accordance with the commonly accepted values of the religion. So, suffice it to say, there's a lot of components to this topic, and actually one of our investment analysts here recently wrote a white paper on this topic, which will be available shortly on the Multnomah Group website, so that you can really dig into this topic in further detail. But what you need to know is that, over time, from the DOL's standpoint anyways, there's been some confusion on the DOL's position with respect to socially responsible investing. So, first the DOL had guidance in 2004 that seemed to support SRI. And then in 2008, there was kind of some controversial DOL guidance that seemed to refute the 2004 guidance, suggesting that perhaps SRI couldn't be considered as part of the process. And then in late 2015, the DOL came back out and issued Interpretive Bulletin 2015-01, which gives plans or plan sponsors rather, the opportunity to use these ESG factors as part of the decision-making process when choosing the fund lineup. So I think, that really, the 2015 guidance comes back out, and it gives the opportunity to say, hey, if there's a tiebreaker, you can use this as a deciding factor, and the DOL says that's always been our standpoint. It kind of takes a step back on that 2008 guidance, and then it says you can use this as part of your regular decision-making process when making decisions with respect to what's going to go into your fund lineup. So for more information on how to incorporate socially responsible investing into your decision-making process, as well as how to evaluate these products from a benchmarking and a screening standpoint, definitely reach out to your Multnomah Group representative, and we can get you that white paper and talk through in more detail how to make that evaluation. The next thing I wanted to bring to your attention is the DOL's audit quality study from last year. So I think we're all familiar with the concept that under ERISA, there's a responsibility to prudently select and monitor service providers. We know that generally, if you are a plan with, the general rule is that if you're a plan with 100 or more employees, you need to have an audit as part of your obligation to file the annual Form 5500. And the DOL reports that, quote, if your employee benefit plan is required to have an audit, one of the most important duties of the plan administrator is to hire an independent qualified public accountant. And one of the handouts that I did include was actually, it's a little bit older piece from the DOL, but it's a DOL piece just about how to find an auditor. So, when you're choosing an auditor, I think, to the extent that you can document the fact that you chose an auditor using some of the kind of language or information from the DOL, I think that that would be helpful. And so their guide on that is included as one of the handouts. But the DOL then further did a study last year in 2015. And the DOL found that there's a link between the number of employee benefit plan audits that a CPA performs and the quality of the audit work. So specifically, when the CPA firm only performed 1 or 2 audits per year, the CPA had a deficiency rate of 75%. And then even still, if a CPA firm performs fewer than 25 audits per year, the deficiency rate was still at 67%. So really not much better than the 75%. So, really what does that mean? Find an auditor that actually does retirement plan audits as their job, not an auditor that just does it as an accommodation, because the DOL is actually watching out for this. And that makes sense. I mean, it's that way with all of your covered service providers. You want to make sure that you're finding someone who really does retirement plan work as their primary line of business, not just as an accommodation, because it is complicated, as you're well aware, and so you want to know that the person who's doing it as your partner actually knows what they're doing. So, when you're searching for an auditor, consider asking questions about their background, their experience, their credentials, and make sure you specifically ask questions related to the number of retirement plan audits they perform and the number of audits their firm does each year. And then, of course, as we always say, be sure to document those responses and put that in your file. Next, we want to move on briefly to the Form 5500. Changes are definitely coming. Last week, I don't know if any of you had a chance to tune in, but last week the DOL, the IRS, and the PBGC hosted a joint webinar. It lasted 2 thrilling hours of getting into the weeds regarding these coming changes. I won't give you a full summary, but I'll give you just some of the high points that I found to be the most applicable. So one of the things we definitely want to note and that they highlighted continually was that these are just proposed changes. They even kind of noted that if you find any inconsistencies in the changes, be sure to let them know. Because it's over 700 plus pages, I believe, of proposed additions and revisions to the form. And the comment letters are due by October 4th. So definitely note, there's a few goals and why they're making the changes. One goal is just to modernize the form and to make it easier to report hard-to-value assets. The agencies really want to get away from having so many things in those other categories. The agencies are also trying to make the form more searchable so that the data is more mineable. So again, they don't want to have all of these attachments. They want to have everything on more, check the box, easy to search type of fields. Another thing that the agencies are trying to do is make it match up or make the Form 5500, particularly Schedule C, match up more with 408B2. So one of the things, there'll be separate Schedule C for each covered service provider to the plan. Another one of the goals is to enhance compliance with ERISA and the tax code. So to that end, with respect to ERISA, one of the questions they talked about, they'll be asking more that will deal with DIAs or designated investment alternatives, so like your fund lineup, as well as QDIAs, so your qualified default investment alternative. So for example, they'll ask what the QDIA is, and if it doesn't fit into one of the available QDIA options under the regs, then of course that would be a red flag to the regulators that you don't know what you're doing, and they'll check you out. So again, these changes won't start until they anticipate the plan year 2019. And again, they're only proposed rules at this time. So if you're reviewing these and you feel like a comment is warranted, be sure to get those comments in because there'll be the comment period followed up by the hearings, and then we won't see the final rules for a little while after that. So 2 more areas that we quickly want to touch upon before turning then to the next slide would be changes in determination letters, and then also the changes to 409A and 457. So with respect to determination letters, note that for 403B plans this doesn't apply, but if you're planned with the determination letter, you just want to take note that changes are coming, and Multnomah Group representatives are happy to talk to you more about that. But the IRS has issued a series of guidance, including Notice 2015-19 and 2016-03. And that those 2 notices describe the changes to the determination letters. So if those changes are going to apply to your plan, definitely check out those notices and we can talk more about that. The next thing I wanted to briefly touch on is that making sure you're aware of the changes to the rules under Section 457 and 409A, which relates to taxation of non-qualified deferred compensation plans established and maintained by state or local governments and tax-exempt organizations. So right now we're in a comment period on these rules. Comments are due on or before September 20th, so we've got, around 20 days or so there. A public hearing will occur on October 18th, 2016, so shortly thereafter. In general, the proposed regulations make certain changes to the existing 457 regulations, and those generally came out back in 2013. These new rules also provide guidance on certain issues that were not already addressed in those existing 2013 regulations, and then they provide additional guidance for 457F plans. So the regs cover a lot of different topics that we don't have time to really dig into today, but they cover things like substantial risk of forfeiture, the definition of deferral comp, and much more. One thing, though, that I think is really noteworthy is that with most regs, you can't rely on those regs until the applicability date. So like with the DOL rule that we keep talking about, you know, the applicability date is not until April 2017, so you don't actually start following it until April 2017. But these new regs under 457, they're different because taxpayers can actually rely on them now, even before the applicability date. So for more information on those regs, you know, certainly feel free to reach out, but I would also advise you to maybe consult with your legal or tax advisor to learn more about those regulations. So we'll go ahead and turn to the next kind of topic in the webinar, which I would describe as noteworthy in retirement. And so, you know, I don't think we'll have time to go through all of these issues today. And really, on these issues, we don't really have action items that you need to take, but they're really more just kind of FYIs for you as those who are in the space just to be aware of. And the one that I really want to bring to your attention is state-run retirement plans. So again, no action items are required as a result of this initiative or these initiatives, but essentially it's just something to be aware of. So with respect to the state-run retirement plans, essentially we have states in the DOL that recognize that there is what many refer to as retirement crisis, or rather people living longer and not saving enough to support themselves, and some people not saving anything at all. So as such, the DOL is stepping in along with some states. And I believe that there are 8 states to date, the last of which was California, that passed state-run retirement programs of some sort. So we have states like Oregon and Washington that have both passed variations of the program. Illinois also did the same. And Oregon's program is set to be in motion by next summer, for example. And the program with these state-run programs was initially collided with ERISA, or with federal law. But last week, the DOL finalized their rules. Those came out and clarified. It was very similar to the proposed rules that these state-run programs were allowed so long as certain conditions were met. So really, you know, what does that mean for you as a plan sponsor? So there are states where, like in Oregon, state-run retirement plans are going to be mandated, and that will not conflict with federal law, as it has now been blessed by the DOL so long as these certain conditions are met. And these programs are seeking to make retirement available to everyone who doesn't already have a retirement program through their employer, so plan sponsors like those of you on the phone. So that doesn't mean, however, that your employees will all of a sudden start having to have both because they would already have the plan that you've made available to them. So just wanting to make you aware that that's something going on in the retirement plan space, and something that you'll probably continue to hear more about as, you know, some states have already passed it. Some states have actually voted on it and shot it down, and so I think it'll probably continue to come up with other states. You know, a couple of the other things just to touch on briefly, there are a lot of other initiatives that, for example, if you go to like the IRS or the DOL website, you can log in and see the kind of what I would call the agenda for both of those organizations, and you can see basically projects that they're working on. Not all of them are just with respect to retirement, so you kind of have to sift through them and see which ones apply to retirement, which ones don't, and other of their initiatives may be applicable to some of you on the line. A couple of them that, I picked out for this slide that we won't go into detail on, but that I think are somewhat important. For example, what I call kind of like 408B2 2.0. I picked that one out, the guidance for service provider disclosures. That one came out in March of 2014 and never really made it any further. So just wanting to bring your attention to that one. That may eventually come back. And then also the lifetime income projections. That's basically something that came out in May 2013. It came out as a proposed rule. And then there was the proposed rule, the comment period, the hearings, and then we've never seen a final rule. But that might come back again. And to bring that one to your attention, because that's kind of along the same lines of this retirement crisis issue and the notion that we should be making participants aware of what their pot of money actually means to them. So it was the idea that we should have a requirement that on participant statements, they should actually have something that tells them, hey, this is what that pot of money actually means when you go to retire. But again, we've never seen the DOL come out with the final rule, but it may be something that comes out in the future. So just to reiterate, nothing on this slide actually requires any action items from you as a plan sponsor, but just things to kind of be on the lookout for in the coming days. So with that being said, we'll go ahead and turn to the slide that just kind of summarizes, action items for plan sponsors. So we've covered a lot of ground today, but I always like to round out the presentation with what does this actually mean for you? So I want to address action items based on holistically all the items we talked about today, as well as even those we didn't talk about today, but that you may find in the handouts provided to you. So first and foremost, keep in mind that perhaps not all of the things we discussed today may apply to you. So the first thing, of course, is just to be sure to determine, did this apply to you or does this apply to your plan? If so, then determine, who are the stakeholders in the organization that need to be involved. So for example, when you're determining stakeholders, you want to figure out, is this a settler decision or is this a fiduciary decision? If it's a settler decision, then it wouldn't need the entire committee. Maybe it's just someone in finance, like the CFO, who makes the decision. But for a lot of what we talked about today, it's really going to be more of a committee decision, committee documentation, because a lot of what we talked about today is more along those fiduciary decision lines that I think are really more committee decisions. So after you've figured out who are the stakeholders, then you'll want to determine, what action items are required. And that's certainly something that we can help with for a lot of these, figuring out what are the actual action items required to comply with any of those steps or some of those questions for consideration. Then you'd certainly want to create a timeline to accomplish your action items, and of course then start taking action. And finally then be sure to document everything along the way and contact us with any questions. So I want to make sure we save some time for some questions at the end. So with that, I'll go ahead and turn it back over to Jennifer, who will have a few concluding remarks, and then I'll take it back over for a short question and answer session before we conclude the webinar today.
Once again, thank you again for tuning into the webinar today. Again, our apologies for the slides not advancing at the very beginning. We will be emailing each of you who participated in the presentation. The participated in the webinar will be emailing you the presentation slides as well as the additional handouts. So if you have any questions, once again, please feel free to use the window on the right-hand side of the screen to enter any questions you might have, and we'll definitely try to answer those questions with the remaining time that we have today. Looks like we have some questions. And then in addition, after you exit the webinar, please take a moment to take our survey, as we really take your feedback seriously and it is appreciated and valued. Finally, be sure to pull out your calendar and mark down Tuesday, September 20th, 10 o'clock a.m. Pacific time for our next webinar, the one that Eric Daly, Multnomah Group principal will be leading. And now I will turn it back over to Bonnie for questions.
Great, so it looks like we do have, the first question is going back to our conversation about the 403B litigation. So one person's asking, can you talk about how long a participant can bring a claim or a lawsuit against a plan sponsor? And so I think what we want to really address here is really just talking about the statute of limitations. So the statute of limitations for an ERISA breach of fiduciary duty claim is 6 years. So we have this statute of limitation of 6 years, but the issue, to my understanding, was first heard by the Supreme Court after going through the Ninth Circuit in the Tibble case. And in that case, the Supreme Court disagreed with the Ninth Circuit and said that there's an ongoing duty to monitor investments that were selected for the plan. So because ERISA is analyzed under trust law principles, if an investment was picked, for example, like in that case in 1999, it doesn't matter if the lawsuit was brought 7 years later outside of that 6-year statute of limitations. There's an ongoing duty to monitor that investment, which essentially resets the clock on the statute of limitations every year that the investment remains in the plan for the monitoring duty, not the selection duty. So what does that really mean for you as a plan sponsor? Well, that means that you can't really rely on the statute of limitations necessarily, because you have this ongoing, you have the statute of limitations, but you have this ongoing duty to monitor unless all potentially bad investment decisions, and I kind of use that in quotes, have been gone for 6+ years. And with respect to Tibble, where is that? Well, it's still not over. It's being reheard again before the Ninth Circuit, but I believe that the general concepts remain the same because it's being heard on somewhat other grounds. So I think, we can really kind of rely on these general principles under ERISA are that the takeaway is you've always got this ongoing duty. Nothing is just set it and forget it. You've got this ongoing duty. So I think that kind of answers the question. So let me look through for the next question here. So we've got one really great question here. Again, I think this is really touching on the 403B here. So it's, please comment on the limitations managing investments with certain record keepers where individually struck contracts appear to impede fiduciary action. What's the prudent step to take? So I think, that's a great question that's raised, and it's really dealing with this issue of, in these 403B plans, what do we do with the individual versus the group contracts where, to an extent, it may be out of the plan sponsor's control because they can only do so much with the ability to move an individual contract. And so, that's something that we've discussed extensively here at Multnomah Group as to what we can do in advising and working with clients on their responsibility in that regard. And so what we've talked a lot about here at Multnomah Group is the extent to which we can work with plan sponsors on a communication plan. So, what does ERISA require? ERISA requires that you do what is prudent, and so what does prudence mean? It's about doing what's reasonable, and of course the problem is that because this hasn't been litigated, there's no set standard of what others are doing. But I think what it really starts with on the individual versus group is having a good communication strategy, showing that you provided other options and that you tried to communicate those available options to those participants in individual contracts. So I think as long as you can document that you have made considerations for alternatives and that you have communicated those alternatives to participants, I think that you are doing the best that you can do. Again, going back to the comment earlier that anyone can file a lawsuit at any time, and of course we don't have great case law there, you know, there's obviously limitations. But I think that's something that we'll continue to discuss with clients. We'll continue to discuss with vendors who have those contract limitations. But I think that that's a great question, and that really communicating and documenting those decisions is really a key thing. Let's see, other questions that we have. So we have a question about, will any of these changes have a financial impact on plan participants? And I think that this question, if I'm correct, is in response perhaps to the Department of Labor's conflict of interest rule. It could also be with respect to the 403B litigation. Either way, I think it's a fantastic question. With respect to the Department of Labor's conflict of interest rule, that's a fantastic question, and I think that to an extent, yes, the financial impact, obviously industry-wide, there's all kinds of trade press articles right now that are talking about the cost of complying with the Department of Labor's conflict of interest rule. And obviously the numbers that are being tossed around are enormous. So a lot of the numbers out there are with respect to what it's taking broker-dealers to comply with the Department of Labor's conflict of interest rule, and they're totally astronomical. The compliance with that rule for broker-dealers is very, very high. For an investment advisor such as Multnomah Group, for example, the cost to comply with the DOL conflict of interest rule is really basically nothing, because our business model, we were already a fiduciary in the past, and so after the new rule, we continue to be a fiduciary in the same way. So that doesn't change what we are doing in any way. We already offered that same service and will offer that same service in the future, so that doesn't change. Where there will be changes for participants is likely with respect to the products that are available. We talked about this a little bit on the last webinar, but a lot of the products, for example, annuities, a lot of the exemptions, the best interest contract exemptions and some of the prohibited transaction exemptions, those are changing. So some of the annuity products with respect to IRA rollovers, that's going to be changing. And so I think inevitably that will change both the products and some of the pricing that's available. But I think it's somewhat too early to tell exactly how that will impact participants. But eventually there will be some sort of trickle-down effect given all of the compliance and legal costs and then the changes in those product structures. So I think that's a great question, and there will eventually be some impact there. Additional questions? We're searching for just a minute longer for some of the additional questions. We had to filter through a few about the slides advancing. We apologize for that. I think that that's all of the questions that we have today. So we appreciate everyone who took the time to tune in. Be sure to download the handouts, and then we'll definitely follow up with the copy of the recorded version, and then feel free to reach out to your Multnomah Group consultant for any additional information. So thank you once again for your time on the webinar today, and have a great rest of the day.